So I've been doing a lot more consultations for clients who um, have recently been laid off or have been recently been told by their employer that they're facing layoffs, and their question is, do they qualify for another type of work visa because, they're about to be terminated from H-1B or TN. So just a reminder that, there is something called an O-1 visa, which is a visa for individuals that have extraordinary ability. Um, I think that more and more people are hearing about the O-1 just because um, of the relative scarcity of work visa types to begin with, right? And as more layoffs seem to be um, on the horizon, more clients are interested in knowing whether or not they qualify. And with the O-1 visa, um, it's interesting because it's like the only visa that allows a petitioner to be an agent, right? So, for example, I have clients who I've helped obtain O-1B visas. Most of them are in the arts or some creative field where they may not have a traditional employment relationship with just one company, right? I have graphic designers, art directors, creative directors who may be working on various projects, and they may have several employers interested in engaging their services. So for a lot of these clients, we were able to have an agent file the O-1 on their behalf and on behalf of all of the multiple employers. So that's allowed under immigration law. An O-1 agent can be one of the employers, but doesn't have to be, as long as it's a person or even like a company who's willing to serve as the agent, which basically means they agree to file the O-1 petition on behalf of the O-1 beneficiary and all of the O-1 employers. As long as there's some kind of written authorization from all the parties confirming to USCIS that this agent has express authority to serve as the agent for purposes of filing the O-1 petition, that might be an attractive option. So that's one thing that's unique to O-1 visas, right? No other work visa allows for an agent to serve as petitioner. Um, so just really quickly, I'll just go over a few criteria for O-1B. So the O-1B is the visa for individuals who can prove that they have distinction in the arts. So what does that mean exactly, right? Um, Generally speaking, if you can prove that you have been recognized as an artist or a creative and that you've received some kind of like national or international acclaim, let's say if you've been nominated for and won notable awards in the field of art, design, that is one type of evidence that you can show to immigration. If you've had your work featured in the media, like periodicals, magazines, newspapers, highlighting your work, talking about your work, critically reviewing your work, then that's another type of criteria. Um, let's say you've had your work exhibited in um, galleries and museums, art fairs, right? So that's a third type of criteria. To file an O-1, you need to show that you have at least three different criteria. So the three that I mentioned are some of the most common types of criterias that my clients have been able to demonstrate. So something to think about. Um, there's two different types of O visas. So the one that I just described is the O-1B. There's another one that's called O-1A, And that is a visa for individuals who can prove that they have extraordinary ability, but in fields that are not art. So this could be science, education, business, um, even athletics. Um, and the criteria for O1A are slightly different, but similarly, you need to show at least three different criteria to file an O1 petition. You can find more information about the O1 by going on USCIS's website. I recommend that you also look at the um, the practice manual. So all immigration officers have this practice manual. You can find it online. There's many chapters. There's a specific chapter addressing O1s. And if you review that chapter, you can find a lot of information about O1s and what kind of evidence does USCIS consider to be sufficient, right, for proving that you are eligible for O1.